Welcome to Courtroom Advocacy for Beginners. Your presenter is Hugh Selby. Watch as our advocate tries to get some detail from the witness.
You have established the distance from the bike path to the hill, but who, if anyone, did you see?
There was a man and a woman.
And did you recognise the man and woman?
Yes, I think that I used to take a bus with them when I was in primary school. I believe their names were Jack and Jill.
You have established that these two people were Jack and Jill, but could you tell me, or could you tell us about the weather?
Yes, it was rainy.
And how did you feel while you were riding your bike in this weather?
Well, as you can imagine, it was quite slippery. I had to watch out for puddles just so I didn't go out of control, that sort of thing.
A smoothly told story attracts an audience. To achieve such smoothness between you and your witness, introduce topics by "let's now go" or "let's move to." That is, use the understood "we", as this includes advocate, you, your witness, and the decision maker. As well as that, repeat the key part of your witness's answer in a following question. This piggyback technique reinforces the message for the decision maker, tells your witness that you're paying attention to them, and gives you a much better memory for the key points of evidence. Good questioning of your witness anticipates how your opponent will later cross-examine your witness. Now that's part of your case analysis. Your aim is to minimise your witness's target size to your opponent by dealing with some aspect of the case in which the witness, their evidence, or both the witness and their evidence, are weak. Because you've followed the guideline of start and finish strong, with weaknesses in the middle, the time for you to confess up and avoid as best you can will be somewhere well into the questioning of your witness. Introduce this weakness subject with a topic heading such as, "Now, let's talk about your long-time dislike of Jack or Jill," depending on which side of the case you're running. Follow the topic with short, incremental, closed questions that will yield a yes or no answer. Now, your opponent cannot object because they agree with each of these facts. They'd intended to use them on cross-examination, but you've stolen what they intended to do. It is likely that they will still ask similar questions, but the effect of the question and the answer of the witness upon the decision maker will be much diminished. Their cross-examination will not lead the decision makers to downgrade their assessment of your witness. However, if you've done nothing to confess and avoid, you've let your witness hang out to dry. For all and any facts that are not agreed by your opponent, you must ask your witness open questions that do not suggest the desired answer. In cross-examination, however, suggesting the answer both to the witness and the audiences is the key to success, as we will now see. A neutral starting point is also good technique for cross-examination. By neutral is meant material with which the target witness must agree and which seems to pose no threat to them. It is nice, not nasty. As with questioning your own witness, move incrementally from that starting point and towards and into your contested issue. This is usually done with short, closed questions. That approach gives good control over the witness. Now, it doesn't matter if the target witness discerns what you're intending to do and takes evasive actions. If your questions are well framed and relevant to an issue, then the meaning and inferences, coupled with an appreciation of what the witness is trying to do, will all be absorbed by the decision makers to your side's benefit. Your cross-examination questions will be a statement of your case position, but put in the guise of questions. For that reason, it is useful to think about cross-examination of a witness as cross-indoctrination of the decision makers. That cross-indoctrination goes to both advancing your own case and undermining the message, the messenger, or both message and messenger in your opponent's case. Your questioning of your witnesses is characterized by your short questions followed by their longer and explanatory answers. Your witness is your storyteller. Cross-examination or cross-indoctrination, however, reverses that approach. Your short declaratory questions, that is, their enclosed form, are followed by even shorter answers. Hence, when cross-examining, you are the synopsis teller of the story. Given the shortness of your questions, the tone and manner of your questions are important aspects of your communication with the decision makers. Use topics when cross-examining, as this shows the audiences the way that you are following. With an opponent's witness, or an adverse, also known as hostile witness that you have called, your control must be overt, as distinct from the covert control in examination in chief or direct. Your opponent's witness or your own adverse witness usually thinks that they are your target, and you should use that perception to your advantage as you question them. Here is a sample of some defence, that's Jill's side, cross-examination of Jack, following the evidence in chief, which you've already heard. Now, sir, you told us just a little while ago that you were quite sure that Jill was just behind you before you tripped, didn't you?
I did.
Now, and you told us that was because you could hear the squelchiness of her movement in the wet ground.
That's correct.
Now, you didn't see her right behind you, did you?
No, I didn't.
Now, until this particular morning, when you'd had that argument, you would never have said to somebody else, Jill would push me down the hill deliberately, would you?
No, I wouldn't.
Because until that morning, the two of you had been in a relationship.
Yeah.
But this relationship had gone sour that morning, hadn't it?
Yeah,
Because of something you'd done.
I guess.
Well, not your guess. You were the one who'd been having a relationship with someone else as well.
All right.
Now, if you'd discovered that Jill was having a relationship with somebody else when you weren't, then am I right that that would have made you a little annoyed?
Yeah.
But you're not the kind of person to take revenge on other people, are you?
I don't think so.
Right. And you're not the kind of person who would have stayed in a relationship with somebody whom you thought would like to take revenge on other people, are you?
No.
So when you set off up the hill that day, you and Jill weren't talking, were you?
No.
And when you think about what you'd done to her, that was fair enough, wasn't it?
Yeah.
I mean, there wasn't anything else you could say to her, was there?
No.
And there wasn't really anything she was going to say to you very quickly, was there?
No.
So it actually suited you that you both went up the hill, but you went separately, didn't it?
Yeah.
And when you got to the top of the hill, you went to fill the pail by yourself, didn't you?
I did.
You didn't say to Jill, "Come and help me, darling," did you?
No.
You were happier to do it by yourself.
That's correct.
Now, you've told us that the ground was slippery because of the rain, haven't you?
Yeah.
And you've told us that you were trying to manage this pail all by yourself.
That's right.
And you've told us that you failed in that attempt, didn't you?
I did.
Because you fell over
Yeah.
and you broke your crown.
Yeah.
And the only evidence that you've put before this court that Jill was somehow to blame for that was because you heard her on the squelchy ground behind you.
Yeah.
You see, you've never said that you saw that staff coming between your legs, have you?
No, I haven't said that.
And if you'd seen it, you would have told us so, wouldn't you?
Yeah.
So when you take all of these things together, it's quite reasonable for people to say, you know, Jack was angry this morning, or that morning. That's true, isn't it?
Yeah, I was angry.
He wasn't in his usual frame of mind.
I guess.
And you didn't do things the way you normally did.
Yeah.
And in a way you felt a bit of a heel, didn't you?
I suppose.
And feeling a bit of a heel, it's nice to push some blame onto someone else.
Okay.
To turn a squelchy ground movement into an act of revenge.
I don't see what you're trying to say.
That's okay. There is never only one way to cross-examine successfully. So here's a second example of the same witness being cross-examined. You'd had an argument that morning with Jill, hadn't you?
I had.
And that's because you hadn't been faithful in your relationship.
Yep.
You were the one who'd done the wrong thing.
Yes.
And having done the wrong thing, you both went up the hill to do your jobs, didn't you?
Yeah.
But you didn't do it the way you normally did you?
I guess.
Well, normally the two of you were happy to do things very close to each other.
That's right.
But because of what you told Jill that morning, she indicated by her conduct that she didn't want to be close to you, didn't she?
I guess.
Well, you went up the hill carrying the empty pail by yourself.
Mm-hmm.
She was behind you, wasn't she?
Yeah.
Carrying that stick.
That's right.
Separate and apart from you.
Mm-hmm.
That's a yes?
Yeah.
When you got to the top, you got the water.
I did.
By yourself.
Yeah, by myself.
She didn't help, did she?
Oh.
She stayed apart from you.
Yeah.
Which is how you'd have expected her to feel, given what you told her.
I suppose so.
And then you set off to go down the hill,
I did.
and you fell over.
Mm-hmm.
And what you want us to accept is that she suddenly decided to come up close to you.
That's right.
But you didn't see her come up close to you, did you?
No, but I heard her.
You heard her on the ground behind you, didn't you?
Yeah.
You didn't feel her push you.
No.
You didn't see her put any of that stick between your legs.
No.
What happened was the surfaces, as you've told us, were slippery and wet, weren't they?
They were.
You were carrying alone a pail that you'd normally carry together.
That's right.
And The only evidence that you saw with your own eyes on the way up the hill was that Jill was quite separate from you.
Well, I think initially she was.
You never saw her any closer, did you?
No.
In the end, you'd like to believe that she set out to hurt you, wouldn't you?
Well, I think she did.
In some way, that makes you feel a bit better about your own bad behaviour, doesn't it?
I don't think that's the case.
You don't think you did behave badly?
Well, I don't think that I'm trying to redeem myself through this. I think she pushed me over.
Right. You think she pushed you over despite your own evidence that through your own eyes you only ever saw her away from you.
Whatever.
In some jurisdictions, there is a rule that an advocate must put to an opponent's witness during cross-examination the advocate's forthcoming contradicting version of events so that the witness can comment. This rule has various names, such as the Puttage Rule, the rule in Brown and Dunn, or the rule of fairness. Now, pretty obviously, the witness will reject the suggestions that you are obliged to put to them. So effectively, the rule is a gift to the prosecution or the plaintiff, as the rule afflicts defence advocates in either criminal or civil cases who are yet to call their own witnesses. As it is inherently a weak part of the cross-examination, bury it in the middle. Ask an open question in cross-examination when any answer will leave your case no worse off. Hence, ask such questions on the following occasions. 1. Only a miracle will save your case. Then be proactive with open questions. There is always the chance that the witness will give you an answer that starts the miracle. Next, only a miracle will save the witness. The witness has performed so badly that they and their evidence have sunk. You can ask open questions such as why, because whether they stay silent or they answer, the effect is the same. In the minds of the decision maker, they're destroyed. And, finally, you need some information. This witness has that information. You cannot capture that information with closed questions. You believe that by using tight, incremental, open questions, you can get that information without also getting information that is more harmful than beneficial to your case. Let's now talk about when to make an objection and when not to make one. Is the question, whether it is yours or theirs, going to bring an answer that strengthens or weakens the evidence about an issue in the case? If the answer is no, then the question is not relevant and it should be objected to. Is the question going to draw an answer that is relevant but inadmissible as a matter of law? If it is such a question, is there an exception at law that will permit it to be asked and answered? If there's no exception, it should be objected to. Is the question poorly constructed, as in a multi-part question, a paraphrasing instead of direct quoting of conversation, or misleading? If it's any of those, it should be objected to. Is the question calling for speculation? If so, object. Is the question suggestive to the witness because there's been a failure to set up the necessary background? If so, object. Remember the two-part basis for making an objection. First part, do you have a good faith legal basis for your objection? Second part, does the tactical benefit of making this objection outweigh any tactical downside? you have been using the 3-part Courtroom Advocacy for Beginners. But now you want to go further. Here's how. Go to court. Go and watch advocates and watch jurors at work. See and hear what works in a courtroom. Then, practice the skills that you have seen to work. As you are practicing those skills, develop a style that uses your personality. And finally, never stop being self-critical as you search for better ways to do what you can already do well enough, but not as the best of all possible advocates.